We are making our way through the early part of our course here, and we are going to cover today the federal judicial system. Basically, we're going to cover Chapter 2 in the CARP book, pages 25 through 53, I believe. If you're looking at what that picture is there, it is the old Supreme Court chamber over in the U.S. Capitol. They don't use it anymore. They used to, and now they have their own building. So, what we have to realize, kind of this semester, this session, is that, if you kind of look at some of the chapters in the book, one of the things that you would find is that there are a lot of things about federal judges and about the Supreme Court we're going to cover at different times. So if you're thinking, it doesn't seem like we're going to cover, some things about, decision making or judicial selection or some different things, or lawyers before and amicus briefs. It's because that we're going to get to those things a little bit later in the semester. And that's kind of where we're at there. So let's kind of think about this. This chapter and section, what we're going to do is we're going to look at the federal court system, and then next time we're going to go to the state courts. The good thing about looking at the federal courts is that there's only one federal government, while there are 50 states, so it allows for some variation. But we really don't have the variation around the country of our federal court system. Now, we have various people in the federal court system, but not a different model. So the historical context. So you have to remember that this is not our first constitution, the one that we have now. So, I have my little pocket constitution that I am in a virtual space actually looking for, because I was going to pretend to wave it around. It's around here somewhere because I just had it the last time I recorded a lecture. Well, trust me, it's here. But it is our second constitution. And one of the things that we have to remember is that our first constitution were the Articles of Confederation. They basically collapsed. What we had there was basically we had a single chamber legislature, no separation of powers, really not much of a, we didn't have a national judiciary. So, we had very much a weak unitary federal government that was pretty much reliant on states. Now, whenever there was a decision that a number of folks made that, maybe we need a new constitution. So, they started having these debates and things, and Article 3, which is what creates the federal judiciary, is like the rest of our Constitution. It was born of compromises. So, you had a lot of different factions in the country that were competing. You had slave states, free states. Now, were there actually slaves in some of the mostly free states? Yes, at the time. Not a lot, but slavery was dying out in the North, and it was growing in the South. You had small states, population-wise, large states. You had states that had designs on some of the territory that were not states west of the Appalachian Mountains. They were almost kind of, some of the states were almost putting like territorial claims to them. You had cities versus agricultural areas. So you had kind of wealthy citygoers and business people versus, let's say, more agrarian and farmers, people involved in agriculture. So you had a lot of different people in the country. So remember, people back then saw themselves more as a citizen of their state than really they did as an American at the time. So there was agreement, basically, that we needed a federal judiciary. but there was some disagreement as far as how we would set it up. So that's why one of the things is that if you were to look at your little pocket constitution, if you have one, or if you don't, I'm sure you could probably find one. Or, one big thing that you could always do is to get on your phone and look up via maybe Google or something, pull up the Constitution. And you would find that Article 1 sets up the legislative branch, Article 2 the executive branch, Article 3 the judicial branch. Well, Article 3 is the shortest one by far. So the longest one is the one that creates the Congress, the legislative branch. Meaning a lot of people think that, well, they give Congress more specific powers. Maybe they meant for Congress to be the dominant or the more powerful judicial body. Now, so the question is, what are we going to set things up at? So the Randolph Plan, sometimes known as the Virginia Plan, would have a Supreme Court and other lower courts, so what we call inferior courts. So am I saying that they're, bad? When I say inferior, it means they're less than the Supreme Court. Now, the Patterson Plan, sometimes known as the New Jersey Plan, would have basically a single federal court. Now, the one thing is, if you just think about that, is that, could you have one court handle all the court cases, all the federal court cases for the country? The country didn't have that many people in it, but still, it's a big country. So, one of the things that those folks were worried about is that they wanted uniformity. They didn't want multiple lower courts. So, kind of the compromise they came up with is that Article 3 said we're going to have a Supreme Court, and then Congress could establish lower courts if it wanted to, which it did. So that's kind of the compromise that you got. So the thought was that that also, state courts would have a lot of power within kind of their own states, and then you could appeal maybe to the U.S. Supreme Court. And that the fact that you had a Supreme Court would provide enough uniformity around the country. So, if you lost at a lower court, you could appeal to the Supreme Court. So one of the things that we'll find whenever we start talking, let's say, about ways that you often get a case up to the Supreme Court, so getting rid of certiorari, is that we have a circuit split. So we'll talk about the circuit courts here probably in several minutes. Is that you want some uniformity is what the law means, what the Constitution means. So, you don't want the law being interpreted. You don't want, say, the Fourth Amendment being interpreted differently in New York than it would be in Florida or South Dakota or Washington or Texas or wherever. So you want some uniformity. So what we get the language, the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. So Congress would ordain and establish a number of courts. Now, notice some things that that didn't say about the Supreme Court. Like anything. It just says one Supreme Court. It doesn't say how many members. It doesn't say where they have to meet. It just says there's going to be one of them. And then potentially a number of courts underneath them. So the Constitution's ratified 1789. George Washington becomes the first president. We have our first Congress. They meet in New York City. Our first capital after the Constitution is established, our current one. And they pass the Judiciary Act of 1789. Keep that under your hat because it's going to kind of come up whenever we get to Marbury versus Madison. So, guess what it was called? Senate Bill 1. You're always wondering what Senate Bill 1 was. I recently went to Europe and was flying to Prague out of JFK, and I actually found out what Delta Flight 1 is. Delta Flight 1 is a flight from JFK to London. I always wondered, was there a Flight 1? It turns out that there is. So if you're wondering what the first Senate bill ever was, um, you know, that's what you get. So you did have, remember, kind of the framers of the Constitution kind of kicked the can down the road. So remember that, if you're kicking the can down the road, now you have an elected national government. So you're having members of the Senate elected. They're elected by state legislatures at the time, no direct election of senators at the time, and then a direct election of U.S. House members from states. So, you have to start thinking that, well, you know what? They're probably going to have some of the same arguments. So, one of the things that was in dispute was this: could you appeal a state level case into the federal system? So some supporters of states' rights thought if you allowed this, you would really basically subjugate the rights of states. But a lot of people were kind of like, some of these state courts, maybe not the most honest group of people. They have their own parochial interests. Some states might deal with things all right. Some states might not. So what we end up with, though, is a larger group decided that we would have a system that included lower federal courts. So what we get is the Judiciary Act of 1789. It sets up a Supreme Court. And the Supreme Court, the original Supreme Court, was going to have 6 members. It was made up of a Chief Justice, separate from the 5 associate justices. And you would have 3 circuits. So kind of the north, the middle, and the south, I think, is kind of the directions that they had. 13 district courts presided over a district court. And as far as the circuit courts, what you had there is that each of the circuits would have two Supreme Court judges on. So one of the reasons that we get the term circuit courts, now Supreme Court members do not serve as circuit justices, is that you had the term ride the circuit. So it turns out that members of the Supreme Court served as circuit justices, I think, up until the Everts Act in 1891. So you just think about that. Think about if you were the justice assigned to the Ninth Circuit and you had to get out to San Francisco. Long trip. It's not like you can just get on Delta or United, or God forbid you had to fly on American Airlines, which is kind of, like getting pretty close to like Frontier anymore. JetBlue's getting pretty bad too. I'm a Delta flyer. I don't mind Southwest either, just they're getting a little on the high side. So the one thing is that the Constitution in Article 3 gave the Congress the ability and the right to set up inferior courts, lower courts. And at the first opportunity, they took it. So it's kind of the genesis of where we get our federal judiciary. Now, of course, our federal judiciary is much larger. We have a larger Supreme Court. They have their own building. We have federal courts around all 50 states and the territories. And we have other courts that we're going to find out about later that are not necessarily Article 3 courts. Now, one thing that I would just tell you to keep in mind is that sometimes you will hear folks, they will use the term Article 3 courts. Now, there is a critical thing whenever we say an Article 3 court. It means that it is one created as a result of Article 3 of the Constitution. So this includes the U.S. Supreme Court, the Circuit Court of Appeals, and the District Court. There are other courts that might not be created under the authority of Article 3. So one thing about Article 3 is for federal judges, you get a life term. It says basically under good behavior. You can be impeached. A few federal judges in history have been impeached and removed. One Supreme Court Justice, Samuel Chase, in the Jefferson administration, was impeached but not removed. So basically, you get these jobs, you can be sitting in them for 20, 30, 40, 50 years. So you can hang on to them for a long time. Now, one thing that some folks might be thinking today, that I'm sure some of you all might be thinking, that, you're sitting there listening to this, and you're probably thinking, oh, 1789 versus 2023, 2024, 2025, 2020. Anytime, let's say in the 21st century. Did people live longer now? Do people live longer now than they used to? Well, of course they do. Of course they do. We have a lot more modern medicine and things. We have where you have refrigerators. You tend not to die of bad water or spoiled milk or bad meat. There's just a lot less ways to die at a younger age. So necessarily, I always have, whenever I come to class in person, if you would go back and talk to the founding fathers of the Constitution and say, was this life tenure thing, which was meant to promote judicial independence, meaning that no matter who changed at the elected level, those members of the judiciary would hang on. But did they mean for people to be on the judiciary for as long as they are? Maybe if they would have known that this experiment that we had called the United States was going to last so long and we'd become quite a pretty successful place, maybe they would have thought that maybe we could say 10 years, 20 years, 15 years or something. So, that's just something that I would just tell you to kind of think about a little bit. Is today this thing about having life tenure, does it still really belong? Or maybe should we have some type of limits that make the terms at least long enough where it takes it out of politics, but we don't have people hanging on for 20, 30, 40 years, or in some cases, we have a federal judge now, I think, on the federal circuit that's getting close to 100 that won't retire. Nobody can make you retire. You can put pressure on you, make things difficult for people. So, what powers would the federal courts and the Supreme Court have? I think that one of the things you have to keep in mind is that, the founders in some cases, were, you just think about it, we're currently the oldest democracy in the world. Had there been democratic governments before? Sort of. You'd had ish in some ways. But, the United States was kind of an interesting experiment. So, one person said, the Supreme Court of the United States is distinctly American in conception and function and owes little to prior judicial institutions. So, does that mean that that was from Charles Evans Hughes, who later became the Chief Justice of the United States Supreme Court? So, somebody that probably knew a few things. Well, where does it go? There's little to draw off of. What powers, of course, we think about today, maybe, like the power between different levels of government and things. Back then, a lot of what we were thinking was the power of the federal government vis-a-vis the states. Because the states kind of saw themselves as kind of like their own little fiefdoms. Again, kind of a little bit less. That they thought of themselves as a lot more than, let's say, we think of states today. What if, would a decision of the federal courts be binding on state courts? So, what about state legislation? Could federal courts only be limited to ruling on federal legislation? What if it implies, let's say, some things within the Bill of Rights or other parts of the Constitution? So, I mean, these were some things that were of great controversy at the time. People weren't really sure. Eventually we learned during the Marshall administration, for example, um, that the Supreme Court can review state court decisions. Now, it's limited later that if a state court is interpreting purely state law and it doesn't implicate federal law or the U.S. Constitution, that generally federal courts will stay out of that. But a lot of states were thinking, well, it doesn't. If our state laws, if they are in conflict with the U.S. Constitution, we don't care. We can do what we want to. That's only a limitation, let's say, on the federal government. Now, the first Chief Justice was John Jay. John Jay did not serve that long as the Chief Justice, because he later would work on some negotiations to settle this conflict we had with France. So we didn't go to war with France. Now, George Washington serves 2 terms and decides, I'm not running again. So up until FDR, we had not had a president serve more than 2 terms. We had not had a president actually even try to serve more than 2 terms until U.S. Grant, who tried to come back in 1880. Now, Theodore Roosevelt had almost 2 terms because he took over, after William McKinley decided to come to Buffalo, which was a big mistake. He got shot down or at the World's Fair. If you go on, I think Lincoln Highway or Road or wherever in Buffalo, there's actually a rock, the McKinley Death Rock, that'll tell you where McKinley got shot. And you can go to the Theodore Roosevelt inaugural site to learn a little bit more about it. You can sit at a replica of the Oval Office. Last time I was there, did I sit at the desk and get a picture? Yes, I did. Did I sit there and also give the Richard Nixon wave with the two V's and my hands up? Absolutely. You would probably be very disappointed if I didn't. When I was in Madrid and standing in front of the Chamber of Deputies, the Spanish Congress, did I also do the Richard Nixon wave in front of there? Yes, I did. Did I do so at the Parliament in Austria? I don't think I did because I didn't have anybody take my picture. But no, I would have. But I always think that in a democratic system of government, so remember, just because you are a democracy doesn't mean you're always going to stay a democracy. We've had democratic systems of government that fall. We have countries that are invaded and taken over. So just because you are a democracy doesn't mean you're going to stay one. But I always think that the most critical election, so remember, George Washington was unopposed. In fact, they wanted to make him the king, and he was like, nah, I don't want to be king. He really didn't seem to want to be president after a while. Is your first election where you have different factions or parties, where you have one side wins and the other side loses and they have to give up power. So while if you look in the encyclopedia, Wikipedia, or wherever, it'll say George Washington, no party. He was more aligned with the Federalist faction than he was with the Jeffersonian Republicans, which kind of end up being our first 2 political factions. We kind of think of as parties. So John Adams was his vice president and narrowly defeats Thomas Jefferson. Now, we had a little bit different system of government back then. So, whoever came in second in the Electoral College, so you didn't have a vote for president and vice president separately, became the vice president. So Adams defeated Jefferson. Jefferson was his vice president. It was not, to paraphrase Taylor Swift a little bit, it was not a love story between the 2 of them. They had once been great friends, became bitter enemies. Very bitter 1800 election. And Jefferson narrowly defeats Adams, thanks to basically flipping the state of Pennsylvania. Um, kind of how Joe Biden gets elected against Donald Trump, flipping Pennsylvania, but also Michigan, Wisconsin, Georgia, and Arizona, um, all of which were not states except for Georgia. And hardly anybody lived in Georgia at the time in 1800. But that is really our nation's first transfer of power from a kind of a not a friendly transfer of power. So another thing was, remember, we didn't just have an election day where we all go out and vote. The Electoral College meets as kind of a formality. They were meeting in state legislatures. A few states had some popular votes, not that many. But the new president didn't take over on January 20. They took over on March the 4th. Also, the Congress took office later. So there was also a disputed election in 1800. Because remember what I was telling you about number one becomes the president, number two becomes the vice president? Well, Aaron Burr was Jefferson's running mate. And basically what was supposed to happen is that one of the people that was supposed to, so you just got 2 votes as an elector instead of 2 separate votes. Somebody was supposed to just not vote for Burr, vote for somebody else. They didn't get the memo, and it was a tie. So the Federalist Congress had to decide the election. And eventually, after numerous ballots, they picked Jefferson. But one thing about John Adams, you might have seen him played on the HBO miniseries by Paul Giamatti, who they did a very good job in giving him very bad teeth to reflect the era at the time. John Adams was a prickly guy, as kind of is Paul Giamatti a little bit. Good choice to play him. I think he won an Emmy for that. But he was not a gracious loser. In fact, he left Washington before the inauguration. Also, another thing is you had this long period of time between when Jefferson and his party were going to take over. So what the Secretary of State at the time, John Marshall, did, in conjunction with the president, were the midnight appointments. So they created a lot of new seats, new judicial seats. And there was a vacancy as the Chief Justice. Adams appoints his ally, the Secretary of State, John Marshall. So actually, during his tenure, he wrote half of all the court opinions. This is not the norm, we'll see. Now there's kind of a division of labor. So this is not something that usually happens. So the court also started writing a single opinion for the majority during his tenure. So we started having a little bit uniformity. So one of the things that eventually happens in 1802 is that when the Jeffersonian Republicans take over, the Supreme Court was reduced to 5 members. It was supposed to be after the next retirement. Now, keep in mind, the number of justices is set by statute. It's set by statute. It can be changed. So if the Congress passed a bill and President Biden signed it that said the Supreme Court is going to be made up of 113 members, it would be 113 members. There is nothing to stop that. Now, one of the things that also happens is this. There was some controversy around the midnight appointments. So Marshall, being the Secretary of State, we think of the Secretary of State today as kind of our nation's chief diplomat. Hillary Clinton traveled in, like over 100 countries on kind of the rickety old State Department plane. Now you have Antony Blinken. You had Rex Tillerson before. Trump fired him while he was sitting on the toilet pooping while he had the flu. Trump liked to brag about doing that. So, you had what's his name, Mike Pompeo. You had Madeleine Albright, Colin Powell. You've had a lot of very prominent people become the Secretary of State. So it's kind of seen as the premier cabinet position that you can have. Namely, probably one of the only reasons that, probably the only position, say, that Hillary Clinton would have taken in the Obama administration, other than maybe vice president if it would have been offered. Well, one of the other things that the Secretary of State has to do is to what we call deliver commissions. What does that mean? You're probably thinking, well, whenever I get appointed, let's say I'm appointed and I'm confirmed as a federal judge or a cabinet official or some type of federal official. Now, does Antony Blinken sit and sign all these things and seal all these things himself? No, not at all. Probably there are some ones where the Secretary of State might, just because it's a big thing, might sign it themselves. But they have like a signature stamp, like some other thing to do. But they have to actually deliver a commission. So, kind of a technical thing. So, there was a Justice of the Peace created. So, for Mr. Marbury. Now, the one thing is, you just think about that. Okay, Marshall's literally a witness in the case, almost basically a party. Probably should have recused himself. Not in this class, but in one of my other classes, I often, ask, why should John Marshall have recused himself? And I put as one of the wrong answers. So sometimes I get some pleasure out of giving some wrong answers that are just really, really wrong in multiple ways. And I put that, Thomas, Marbury was blackmailing Thomas Jefferson because he had lewd photos of him and Sally Hemings together. And, the one thing that most people probably should have thought of is like their photos weren't invented yet. Like somebody would have had to done a portrait. And it's just kind of a ridiculous thing, too. And still some people choose it. So Marshall also had to worry about this. What would Jefferson do? There was, the Jeffersonian Republicans were talking about impeaching some of the members of the Supreme Court, including him. So what about the prestige of the court? This was, you think about this, you're in 1803. The country had been around under this Constitution for 14 years. You're on your third president. So you're not exactly went through too many people. So what to do? So, Marshall was the Chief Justice for 34 years. He had a lot of impact. Now, by the time that he leaves, it kind of goes into the sway of Roger Taney and the Jacksonian Democrats. But he writes a brilliant decision. He says that Madison now, so we're now up to Secretary of State James Madison, who succeeds John Marshall. So whenever Madison became the Secretary of State, he was like, I'm not delivering this commission. Jefferson and Madison and a lot of the Jeffersonian Republicans were thinking these midnight appointments were a bunch of BS. You shouldn't have done it. We aren't going to go along with it. But he said he should have done it. He had a duty to do that. He said also Marbury had the right to the commission. But then what he said was, what? Part of the Judiciary Act of 1789 is unconstitutional. That when he asked for the writ of mandamus, it was unconstitutional because it granted original jurisdiction in the Supreme Court in excess of what Article 3 said. So basically, as far as you can't add original jurisdiction to the Supreme Court by Congress. You can actually do some things with appellate jurisdiction, but you can't add original because basically there's a short list of things that can be heard in original jurisdiction. The main one is just disputes between states, so you can't add to it. So Congress violated Article 3 by adding this new jurisdiction. So the decision meant, really what we see, is that it establishes judicial review. So if you're ever wondering, if anybody asked you, what is the most important Supreme Court case in history? It's this one. It's Marbury versus Madison. You're probably thinking, well, there's a lot of other big ones. Brown versus Board of Education, pretty darn big. It definitely is in my running for number 2. But you don't necessarily get other cases until you get judicial review. That the Supreme Court can strike down laws. Eventually, you're going to find they can strike down laws of state courts. Now, was this the first time that the Supreme Court actually had reviewed a federal statute? No. They'd actually done that with a tax on carriages in Hilton versus the United States in 1796, but they upheld it. This is the first time where they said no. So, like I said, eventually it applies to state and local governments. So, the Supreme Court has not always been where it is now. So, it's in a nice building. I was going to say new. For Washington, it's new. So, finished in 1935. So let's look at a little clip here where CNN is getting a tour of inside the Supreme Court building, which a lot of it you can tour. Not the private parts where the offices are, but you can go on the floor where the Great Hall is and where the portraits are on the first floor. So let's take a look here.
The Situation Room with Wolf Blitzer, weekday afternoons at 5 Eastern on CNN.
This is part of the architectural plan to try to make the appearance of the court feel monumental and to give the sense that there's important things happening in this building.
We're in the Great Hall of the Supreme Court, about to enter the most important courtroom in the land. The Supreme Court's impact is almost immeasurable. Few ever have the chance to get behind the scenes of this iconic building. Only 2 pictures exist of the court actually in session, and those cameras were smuggled in the 1930s. But on the 75th anniversary of the High Court's home, we gained rare access to this place.
It's sure to surprise many people that this building's actually the permanent home of the Supreme Court's only 75 years old, which is kind of young in relative terms to many of the buildings here in Washington.
Right, exactly, and that was one of the tasks that was assigned to the architects. They wanted to make sure that this building blended in with the Library of Congress next door and also with the Capitol.
For almost 150 years, the Supreme Court was basically homeless. The court met in New York City, Philadelphia, and then the old Senate chamber in Washington. Not until 1929 did then Chief Justice William Howard Taft finally convince Congress to fund construction of a permanent home. The building opened in 1935. Catherine Fitz is the head curator here.
Marble is most definitely the predominant material that's used. In fact, out of the original $9.7 million, they spent about $3.5 million just on the marble alone. The design for the building is a Greco-Roman temple, kind of a temple of justice.
A beautifully wood.
The High Court's associate curator, Matt Hofstad, then took us to the court's law library, an historic place where justices have long visited to consult the wisdom of justices past in the library's 600,000 volumes.
The library is a very vibrant part of what the court does because you need that sort of scholarly input in the opinion writing process.
Now, with the ease of the internet, the library isn't used nearly as much, but this room is a different story. It can never be replaced. The courtroom where historic cases such as Brown v. Board of Education, integrating public schools, Bush v. Gore, and many more have all been decided.
Oh, yay, oh, yay.
And the courtroom, in tradition and even furniture, has gone virtually unchanged since the first case was heard.
Some of the traditions you'll see here in the courtroom are the 3 justices come out in 3 groups from behind the red curtains, and some of the other traditions are, to this day, the court still puts quill pens at the desks of the attorneys who will be arguing before the court. Sort of a throwback to the John Marshall years.
Still, the justices are notoriously camera shy, and much of the government building, like their chambers, remains off limits. And while a grand building, we found the little details hidden from most visitors are what give the court's home its power and charm. Ornate carvings above the courtroom showing great lawgivers of the past, like Moses with the 10 Commandments and a rare image of the Prophet Muhammad. Small turtles on the lampposts outside signifying the deliberate pace of justice. And portraits of every former justice lining the walls where the new justices are sworn in.
This allows you to go through the history of the court in only 16 or 17 people. And we've had 44 presidents now. There's only been 17 chief justices in that same period of time.
An ever-evolving court, yet a place built on tradition and an institution leaving lasting imprints on the fabric of American society. But on rare occasion, that imprint works the other way around. These sweeping doors leading into the court were meant to symbolize access to justice for all. But they've now been closed as a public entrance because of security concerns. Kate Baldwin.
The situation.
That is interesting. So, like I said, you can tour part of the building. If you get lucky, maybe you can see an oral argument in person, but no cameras in the courtroom. So, a lot of the justices, kind of like their anonymity. So, this, with 24-hour news and a lot of other stuff, I think members of the court are more anonymous than they used to be. But, I could say probably other than maybe the Chief Justice, probably other than a few of the, I'm trying to think who today probably is the most anonymous member of the court. It was Breyer for a long time. That probably the fewest people could name. If I had to guess today, it would probably be Kagan or Gorsuch. Would be my guess for probably most anonymous member. You could probably have one of those two walk down the street, and of 100 people, probably just a handful would recognize them. Now, what about the Supreme Court as a policymaker? Well, you just think about this. Well, the president's elected. It's elected indirectly through the Electoral College. Today, the House of Representatives, of course, has always been elected. The Senate is elected now. It's been elected since 1917 through direct elections. Supreme Court isn't elected. Now, a lot of the checks and balances is that members of the Supreme Court are appointed by the president and confirmed by the Senate. But one of the things is that the Supreme Court decides big issues in some cases. Now, whenever they're handing down their decisions, so I think last year they did like 57 opinions, not a lot compared to what they have in the past. There's a winner and a loser, unless they say they dig the case, dismisses and providently granted or something. Well, sometimes these can have major effects, as we've seen in the past and we'll see in the future. The Supreme Court has decided many issues and sometimes reversed itself. So in 1896, the Supreme Court handed down a decision called Plessy versus Ferguson. If you take Political Science 301, you'll read about it in detail, as you would with Brown versus Board of Education. In Plessy, the court said, segregation of the races we approve of. No problem with the 14th Amendment. Later, 58 years later, in Brown versus Board of Education, they said school segregation is unconstitutional. You just think about in 1954, outside of outside in the South, this was kind of a groundbreaking decision. It led to the Southern Manifesto, massive resistance, massive opposition to the civil rights movement by most white Southerners. Think about how big of a decision that was. Literally telling the South, your entire social structure, the way you run things, vis-a-vis people of different races, you can't do anymore. It violates the 14th Amendment. But we have seen other policies that have come and go. Abortion. The Supreme Court in 1973 says abortion is a protected right. In 2022, no. 1978, the Supreme Court approves of affirmative action. 2023, they don't. They end up setting the standard for sex discrimination as far as the 14th Amendment because the states never approved the Equal Rights Amendment. At one time, the Supreme Court said the death penalty is unconstitutional. Then they said it is. Then they said it's fine under limited circumstances. Then the Supreme Court on the death penalty started, limiting the death penalty. Now they're increasing it. What you can do. The Supreme Court, of course, has been, under this conservative majority, been very hostile to labor rights. So, if you're a public employee, you do not have to join a union if you don't want to. Thanks to the Janus case. Now, the Supreme Court is the final arbiter. The interesting thing is that it's a court that is different. It's a court of both original and appellate jurisdiction. Now, the original jurisdiction that it has is pretty rare. So, on average, whenever I teach some of my common law classes, I'd actually look this up. On average, they do one case in original jurisdiction every other year. So about like half a case a year is the average. Almost all the cases are of appellate jurisdiction, where a lower court's made a ruling, and it could be a lower court at the federal level or the state level, and the Supreme Court is deciding whether that decision at the lower level was correct or incorrect. So all decisions by the court are binding on the entire country, and they're final. The only way you can overturn a constitutional decision, now if it's a statutory decision, it's a little bit different. So if the Supreme Court makes a ruling that they say is based on the U.S. Constitution, there are two ways that can be overturned: a constitutional amendment or a subsequent decision. There have been only 4 or 5 times, depending on how you count it, when a Supreme Court decision was reversed by a constitutional amendment. So remember, after the Bill of Rights, since 1789, when they were ratified, since then, and we're getting close to 200 and trying to do some math here without taking off my shoes. We're over 230 years. The Constitution has been amended 17 times since then. So not that often does the Constitution get amended. The Constitution hasn't been amended since 1992, and that was kind of a technical thing where they passed some constitutional amendment from a long, long time ago involving congressional pay retroactivity. The last actual substantive, so basically that basically meant nothing, the 27th Amendment, to be honest with you. It's probably the least consequential amendment to it is the least consequential amendment to the entire United States Constitution. It means basically very little. It basically means nothing. The last substantive time, I think, was in 1971 or 2 with the 18-year-old vote. So Congress had tried to lower the voting age to 18. The Supreme Court said, no, you can't do that statutorily. So it was passed by a constitutional amendment, easily ratified. It was during Vietnam. A lot of people were starting to think, hey, I can be drafted and you can send me off to die in Vietnam at the age of 18, yet I can't vote. And a lot of the people in the United States are kind of like, that's a good point. Maybe we ought to change that. So a number of states had already lowered their voting age to 18, so it just made it federal law. How do you get the Supreme Court to reverse a case? You usually have to wait a while and get some different justices, as was the case with abortion rights, affirmative action. So, had times changed as much, or had the makeup of the court? Probably you have to say the makeup of the court. So the process, they've had their own building since 1935, as you saw there, getting a case heard. So we're going to cover this in more detail later, just to let you know. What you need is a writ of certiorari. The key thing is that it takes 4 votes to what we call grant cert. So it's meant to be where the majority of the court can't control the docket. But the one thing that you have to remember, if you're the 4 justices and you can get the case heard, well, what if you have 5 votes that are going to go against your position? So there is some, as George W. Bush would say, or at least the Will Ferrell version, strategery going on. So the court today meets from October to June, oral arguments from October to April, 60 to 90 opinions per year lately. Actually, it's been less than that the last few years. As far as oral arguments, they don't hear them that much. Generally, basically each month they're hearing between about 6 to 11 cases over like 3 days a week for 2 weeks. So like 6 days they're sitting and listening to oral arguments. So attorneys argue the case is peppered with questions from the justices, though I'll get to when we get to talking about COVID here in just a little bit, is that you've had some oral argument reform that I think was probably necessary, that was actually good. So case conferences. So, actually today, oral arguments with the reform run more like about 90 minutes, given the way that things have changed. But in bigger cases, sometimes there will be a lot longer. So, for instance, when the Affordable Care Act case that we'll talk about in the Tubin book later in the semester, it was over 3 days just for one, well, it was consolidated cases, but one basic case. Again, there are no cameras in the courtroom. It's an older picture there before you have any of the Trump appointees on the court. You can see that Kagan and Sotomayor are the younger members on the court there. And Scalia is still there. So is Ginsburg. So, a number of people still on that weren't there before. No cameras. So the only thing you have are these sketches. You have sketch artists in there. So case conferences. This is when the Supreme Court members, nobody else is allowed in the courtroom. And in fact, there's an inner door and an outer door so that nobody can be like standing near the door listening. So the most junior justice is responsible for watching the door. Sometimes they're known as the note taker or the coffee person, because like if somebody knocks on the door or they need to get something, the most junior justice will go from the inner door to the outer door to somebody that's outside. So no one else is allowed in there except the 9 justices. So the chief speaks first on a case and then in descending order of seniority. Then the vote takes place in the opposite order. The most junior member votes first and then over to the chief. Remember this, the chief is always the most senior member of the court, even if the chief has been on the court for 1 minute. Ties result in the lower court ruling being upheld without any precedent. So generally, because the court meets for oral arguments, usually Monday through Wednesday. Sometimes if there's a holiday on a Monday, maybe it might meet up to Thursday. The conference is Wednesday afternoon or Thursday afternoon. It just kind of depends on the schedule. So as far as their conferences. So the quorum for a conference is 6. It's hard not to get that. So, if you're wondering during COVID, did they do a lot of stuff electronically? Yes. If there's emergency petitions or some different things, do they meet other ways, like just kind of send stuff around? Yeah, they do. Now, written opinions. Opinion assignment is very important. It's very important, by the way. So it goes by seniority. So whoever is in the majority, and they are the most senior justice, they get to assign the opinion. Now, I'm going to show you a clip here that's going to be very instructive. So I'm going to ask you several times on exams, who's the most senior justice on the Supreme Court? If you answer Clarence Thomas, I can tell you right now, you did not listen to this lecture. He's the longest tenured justice, but he's not the most senior. The chief is. Chief Justice is a separate position from all the other justices. John Roberts is the chief. He's not God by any means, but that is his most critical power. That he makes $13,000 more than the others. He gets to preside over impeachment of the president and gets to swear in the president, but his critical thing is if he's in the majority, he gets to sign the opinion. Even if there are other people that have been on the court longer. So if the Chief Justice is not in the majority, then it goes in the order of seniority. So it would go Thomas, Alito, Sotomayor. And this applies to the dissent as well. Whoever's the most senior in the dissent gets to assign that as well. So it's the goal later of the opinion writer to try to generate a majority. Now you can see there, that's the room that they meet in conference. One of the things is that all the justices make sure that they shake everybody's hand in there. So you can see that they have their little things where they can have books and things. I'm guessing that they probably have some electronic stuff now. Though you've had some justices that, even recently that have eschewed a lot of electronic things. Now, if you're thinking, about the Chief Justice, it's probably in their benefit to be in the majority. If you're thinking that, you're right. But types of opinion, majority. It's the opinion of the court. It means you have 5 votes or more. A dissenting opinion, you disagree on the result in the law. A concurring opinion, it depends. It depends if it says concurring or concurring in judgment or concurring in result. So it usually means that if it just says concurring in judgment, you agree on the result but not the law. So you reach the same conclusion, but you get there a different way. Now, per curiam decision is an unsigned opinion. Usually less controversial, probably becoming more as you start to get with the shadow docket, emergency relief, that usually are unsigned opinions. This is becoming bigger and bigger, the shadow docket. It's something that Will Bode, who's a professor at the University of Chicago, who actually I had his dad as a law professor at Indiana, Pat Bode. Turns out Pat Bode, very, very liberal, like a Bill Brennan Democrat liberal. His son is like a Federalist Society guy, though has written recently an article with somebody else that argues that Section 3 of the 14th Amendment says that Trump can't run again. Interesting argument. I don't think the Supreme Court would buy it. I think that they would think that it's a political question. Actually, frankly, I think it's a political question that, unless there's some type of conviction or something, that, leave it up to the voters. Promised clip.
Sir, what was the vote on all eight?
We're going to hear the case. Although no knows why. Bill Brennan's doing it. Politics his way around it with him. On Phillips versus Marietta, I want you to draft an opinion that under the Civil Rights Act, an employer may not, in the absence of business necessity, refuse to hire a woman with children of preschool age.
Sir, that's not what you told us before conference. You said the employer was within his rights not to hire the woman. You said you were upholding.
That was a tentative vote. David, did you get hold of the court plans?
They were on your desk, sir.
Thank you.
He just changed his vote? Just like that?
There's no mileage in voting with a minority. If he votes with the majority, he gets to assign the opinion, or write it himself.
Good thing about Bill Brennan. He's got a nerve.
Chief's always pulling the strings. Do not underestimate him. Sir?
So, what he said there. Notice those were law clerks sitting around there. That was Franklin Gella playing Warren Burger. Warren Burger changed. Warren Burger was notorious for doing this. If you ever had me for Political Science 305, the judicial politics class, some of you might have taken it though with other professors. I mean, we all teach it a little bit differently. So Professor Hinkle and Professor Matthews teach it as well. I think I've taught it probably more lately. Some of you might have had that with me. You probably know a lot about Warren Burger being kind of a pain in the rear end. So let's move on to kind of the last third of our lecture today, kind of looking at the lower federal courts. So the U.S. Courts of Appeal. So members of the Supreme Court originally sat on the Courts of Appeal. So also at one time, district court judges sat on the Courts of Appeal. So today, only circuit court justices do that. But we have what are called senior judges can sit on panels as well. Those are kind of people that have what we call take senior status. So they give up their seat technically, but they can still work. So it's kind of a way. So there are a few things that it kind of means. Is one thing is that you can draw your salary and your pension at the same time, which is nice. But the other thing is you can kind of time your retirement and still work and make it where you can assure potentially a like-minded successor succeeds you. So there are 12 geographical districts. I'm going to show you the map here in the next slide, plus the federal circuit, which is different from the D.C. circuit. So the federal circuit handles a lot of patent cases. The D.C. circuit is kind of known as, sometimes people think of it as the second most powerful branch of government after the the second most powerful court in the country after the Supreme Court, because it hears so many cases involving federal laws, because it's literally just the District of Columbia. It has 11 judges. So it's different from the D.C. circuit. So the federal circuit, I already told you, it also hears custom cases. So the last circuit that we call was split. So remember, there were originally 3 circuits, like the north, the middle, and the south. Or was it? It was either that, the east, west, middle. So, you kind of divided up the 13 colonies in 3 ways. Now, the Fifth Circuit used to be most of the South. Later, it was split up into the 5th and the 11th circuits. So you can probably think, okay, there were originally 3 circuits, and now there's basically 13 of them. There's been some creation of new circuits. Now, just to let you know, originally kind of the way that the Supreme Court grew was the addition of different circuits. So really the number of justices we should have on the Supreme Court should be 13. Now, am I advocating doing it now? No. I'm saying that it should have happened a long time ago, that the number should have increased a little bit. But the number of the Supreme Court members eventually went to 10. Then they kind of like, maybe we don't want an even number. So it eventually backed down to 9. So with the number that we have, so meaning that if each justice had assigned as for emergency petitions 1 circuit, it would be 13. So the number would have increased from 12 in 1980 to 13. So I'm just saying that would be the proper number based on kind of historical precedent. But what I am also saying is that the number when it should have grown was a long time ago. So, with some of the others, it probably should have grown like about 100 years ago. So the number of judges and circuits are dependent on acts of Congress. So here are the circuits here. As you can see that there are 11 numbered ones, the D.C. Circuit and the Federal Circuit. The interesting thing is that the First Circuit up in Boston has Puerto Rico. The Third Circuit in Philadelphia has the Virgin Islands. The Ninth Circuit has a lot of the Pacific territories. I just think it's interesting how kind of some of these things get put together. One of the things that that you kind of look at there is that do all the boundaries look best in the world? Really, no. You probably think Kentucky, Tennessee, Ohio, and Michigan. Kind of an interesting grouping there. Or So one thing is that they vary in numbers. So the First Circuit in Boston has 6 members. The Ninth Circuit in San Francisco has 29. Now, some Republicans have moved to try to split the Ninth Circuit. So basically make the Ninth Circuit California and a new 12th Circuit hold all the other states and be in Phoenix. And as the place that it would sit. Probably at the time they were thinking Arizona was a lot more Republican than it is today. But the thought was that you had so many judges from California that are very liberal, and the other judges in the other states. So each state kind of, while not formally has different circuit justices, it's kind of by tradition each state gets so many within the grouping. So, for instance, you look at the Second Circuit, New York, Vermont, and Connecticut, most of the judges are in New York. Now, if you kind of look at, you can see the state boundaries there. You probably also see some little dotted lines between the states. Those are the federal district courts. So, some states have only 1 district. So, you just think about it. I mean, some states, it's pretty obvious. Do you really need more than 1 district in Wyoming or the Dakotas? Or do we really need more than 1 Dakota? Interesting question there. You look at some states and kind of like, we've got a lot of people in Arizona, Colorado, Minnesota, yet they only have 1 circuit. 1 district. Yet, Texas, California, New York have 4. So, I mean, it just kind of depends. So, one thing that I would just tell you is that part of the U.S. Constitution under the 6th Amendment is that at the federal level and at the state level, you can't change the venue outside of a state for a state level case. You can't change the venue outside of a federal district for a federal prosecution. So you might notice that the former president has had some legal charges against him, former President Trump. So one of them is in the District of Columbia. So that is the U.S. District Court for the District of Columbia. So I've heard some people say, on the right trying to, because the one thing is, I mean, it's not a great location for Trump to have politically to have a trial. I mean, he got 4% of the vote in the District of Columbia. If it was a state, it would be by far his worst state. If it was his own congressional district, it would be by far his own worst congressional district. Say, well, we should move it out of the District of Columbia. The Sixth Amendment says you can't. It has to stay there. It does. So it can't move out of there. So that's where the alleged crime was committed, or charged to have been committed, I should say. Until you have a conviction, I can't say that it's been committed. It's alleged to have been committed. So no, you can't move it to West Virginia. You can't move it from like your least favorable place to your most favorable place, or you can't move it to any other place outside of the district. Just like the one in South Florida, you kind of look there at the bottom of Florida. You can't move out of there. Now there are different within a district. There are different divisions. So in our Western district there, we have like one in Buffalo and one in Rochester. So kind of split. So, maybe, if you had too much pretrial publicity in Buffalo, maybe you could get a jury in Rochester. But, you couldn't go to Albany or Binghamton or Syracuse or New York City or Brooklyn or Long Island. So just to let you know there. So you can take a look at this map here later at your heart's content. The one thing I just wonder is that why they chose to use the same color for the 6th and 7th circuits that are right next to each other. Because it kind of makes it look like it's one big group if you don't look very carefully. I went the wrong way. So, review function. It's not a discretionary docket. They have to hear appeals as of right from the federal district courts. So the docket depends on the number of cases appealed to them. You don't have to appeal a decision. But the circuit courts also review cases involving administrative agencies. So you have administrative judges with Social Security, Medicare, Medicaid. So I have a good friend of mine that's a retired federal judge. He heard appeals from Medicare. Made a lot of money doing so. I mean, federal judges are well paid. So cases ranges from things that are very non-meritorious appeals to things that are very important. So, a lot of the thing with the circuit courts are a lot of a division of labor. So handing things over to a lot of the circuit courts to look at things. So here's the one thing that I think you have to remember is this. And we kind of get to this when we talk about the policy-making function. Screening 3-judge panels, we'll get to that in a second. So again, I spent more time on the Supreme Court part. I'm going to kind of go through the circuit and judicial, the district court parts a little bit quicker. There are thousands of cases that the circuit courts hear, many of which are non-meritorious, easily disposed of. The Supreme Court here heard 57 cases last year, meaning that the decision you get from your circuit court 3-judge panel probably is going to be the final decision. Now, the main functions to review lower decisions for errors. They do not retry the case. That's not a de novo review. So basically, the other thing that they might do, and one of the things you have to remember is 8 of the 9 current justices are former circuit judges. 4 of the 8 were in the D.C. Circuit, including Judge Jackson, Chief Justice Roberts, Justice Thomas, and Justice Kavanaugh. They're also maybe looking for cases that they are thinking might work their way up to the Supreme Court. Also, some of these judges might be thinking, I'd like to be on the Supreme Court. Maybe I'm going to start writing, doing certain things to get myself noticed by one of the Democrat or Republicans that are putting together a Supreme Court list. Policymaking functions. Decisions are binding only on the states within the circuit. So they're very ideological and partisan makeup of the circuits. So President Trump was very successful in getting a lot of circuit judges confirmed. One of the things that really helped him is that we'll talk about this later when we talk about judicial selection and things. So during the Obama administration, Mitch McConnell, you might have heard of him in the news a little bit, was very successful in blocking a lot of Obama nominations. So during the last 2 years, he blocked Merrick Garland from even getting a hearing. But even before that, Republicans were using the blue slip really to keep a lot of circuit and district court jobs open. Democrats didn't really, at least at the circuit court level, Republicans quit honoring that. When Democrats took over, they were kind of like, you didn't honor it, we aren't going to honor it either. Left a lot of openings, especially in Texas, meaning that Trump had a lot of vacancies to fill on the Fifth Circuit Court of Appeals, the nation's most conservative circuit, with James Ho, kind of somebody that I think that the next time you have a Republican president will probably be the first Republican, I'm assuming Republicans have the Senate as well, I think will be the first Republican Supreme Court nominee. Write that down. James Ho, Federal Circuit Court judge in Texas. Very conservative. So circuit courts at work. So cases have to be heard. Some can be disposed of easily. Most don't get an oral argument. Some might just get a very small oral argument, maybe a few minutes. So cases are heard by 3-judge panels. So someone assigns the panels and the cases are assigned, and then the cases are assigned to them. So these panels can contain senior judges. So you might be thinking, okay, what if I get what we call a bad draw? Especially if it's more of a type of ideological case. So, let's say the circuit overall leans very conservative. And I just happen to get 2 liberal appointees. 2 liberal judges. Well, then there's a choice later of an en banc rehearing of all the judges within the circuit. Now, that excludes senior judges. So remember, the thing is, within the 3-judge panels, you can have those senior judges. So it kind of scrambles a little bit of the appointment process. So how do you get these 3-judge panels? It depends by circuit. Sometimes you don't know until the judges maybe walk into the room who the 3 judges are. Now, the exception is the 11th Circuit. It has 29 judges. So it's a randomly selected 11-judge panel that hears a case, what we call en banc. En banc means that all of the judges hear the case together. And they make a ruling. So this is often, if you get what we call a bad draw, you want to appeal en banc. So this is a discretionary appeal. So I remember one of the things is Professor Hinkle had clerked for a judge on the 6th Circuit, and she was telling me that it's 16 judges, and they meet in Cincinnati, and that they're kind of crowded up on the little dais that they're on, and said that there's one of the chairs that sometimes kind of you have to watch. That one of the judges might kind of fall off of the dais. You don't want to see somebody fall, but you have to admit that could be a little bit funny. So decisions are announced, can be announced immediately or after oral argument or after a period of time when the judges confer and decide who's going to write a longer opinion. So it kind of depends. Now, the workhorse of the federal court system are the district courts. Current organization, these are set by Congress. So like I said, you have Minnesota and Arizona and Colorado have one district. Does it really matter that they only have one district? You can always create multiple judges within the district. So there are currently 93 districts and 678 district court judges. The largest district court is the Southern District of New York. Sometimes it's known as the Sovereign District, especially with the U.S. Attorney there. Sometimes they think they're like basically the equivalent of the Justice Department. So some states, including our state, are divided up, which is divided up 4 ways along with Texas and California. Some states only have one. Just because you only have one district doesn't mean that there might be where judges have their own duty stations. So as long as there's a federal courthouse, so sometimes you might have federal courthouses where there's not a judge that regularly is there. So in my home state of Indiana, for instance, because I have a very good friend of mine that is a assistant U.S. attorney. So there, in the Southern District of Indiana, there are 4 courthouses: Indianapolis, Evansville, Terre Haute, and New Albany. New Albany is like 20 miles from where I'm from and where Lauren's from too. So there's no regular judge in Terre Haute or New Albany. And basically there's kind of a part-time judge where she works in Evansville. Well, how do they work that? So maybe the judge, so there's a judge in Indianapolis that will sometimes come to New Albany, 2 hours south of there. Or we'll go to another one that goes to Terre Haute, like an hour and a half west. So again, just because you have multiple just because you only have one district doesn't mean you don't have multiple courthouses around there. So the DC and the territories have their own districts as well. So they have basically a trial court function. So the only federal court that act as trial courts. So they have exhibits, witnesses, and may have the jury as a trier of fact. There may also be bench trials that can be waived where the judge is the sole trier of fact. So the charges are done via indictment via grand jury. So we'll talk about that when we get to criminal cases. So policymaking functions. So district courts have less of a policymaking function than circuit court, but still have a role. District courts can make important rulings in cases of a first impression. So one of the things that I think that we're getting to more is the fact that we have what we call nationwide injunctions that district courts can issue. So, you know, we started to see this a little bit during the second Bush administration. We started seeing it a little bit more during the Obama administration, a little bit more in the Trump administration, now during the Biden administration, is that sometimes you shop forums trying to, now remember, different districts are going to have different judges, but let's say you go to a different division within a district. Maybe you make it where the number of judges there, instead of 25 judges, maybe it's 4 judges. So, for example, whenever the charges were filed against Donald J. Trump in the Southern District of Florida, there's like 25 judges. You're probably thinking, well, how did Eileen Cannon, who had had some rulings that had gotten overruled by the 11th Circuit, get the case? Well, because the box for Palm Beach County was checked. It put it in a different division, which put it also like in the Fort Pierce division where she sits. So it was like a 1 out of 4 chance. So we're going to see this with Matthew Kaczmarek, where it was kind of like a 1 out of 2 chance because the lawsuit on the abortion pill case was filed in Amarillo. So 3-judge panels are rare. Congress can authorize them. So this can be done in redistricting cases. So Congress has authorized a 3-judge panel containing at least 1 district court judge, 1 circuit court judge, as far as that, to bypass the Court of Appeals. So that's just kind of something there. So I'm going to show you here this part of this clip here from Chris Hayes' program. So last time I showed you Fox News, now you're getting MSNBC. So we're getting fair and balanced. There we go. About how a little bit more about Judge Kaczmarek. So where the plaintiffs challenging the FDA decision on the abortion abortion pill, we're specifically thinking, okay, we're going to get this guy. Let's take a look.
Good evening from New York. I'm Chris Hayes. Today, the fate of millions of American women's reproductive health is once again in the hands of a far-right judge. This morning, federal judge Matthew Kaczmarek of the Northern District of Texas presided over a hearing in the small city of Amarillo. A coalition of anti-abortion groups brought this case, seeking to overturn the Food and Drug Administration's approval of a medication commonly used in abortions. This drug has been on the market for more than 20 years. It has been proven to be safe and effective. In fact, millions of women take it every year. It is taken along with a second medication to end pregnancy in the first trimester, which is the method used by more than half of all women who have abortions in this country. Of course, this comes in the wake of the anti-abortion movement's success in overturning the right to an abortion enshrined for decades in Roe versus Wade. So abortion is now illegal under a near complete ban in 13 states, seriously limited in 5 more. And medication abortion is even more important in those areas with restrictions or limited resources because it is easier to access. But now it is possible that this one judge could pull this drug off the shelves, not just in those states where they've banned abortion, across the country, everywhere. With the stroke of his pen, he could conceivably cut off access to every woman and pregnant person in a nation of 300 million people. Now, you may be wondering, how is that possibly the case? And also, why is all this happening in Amarillo, Texas, of all places? And those are good questions. Because the first thing you have to understand is that the judge in question here is a product of one of Senate Republican leader Mitch McConnell and Donald Trump's most successful projects during Trump's 4 years in office. Together, they rammed through more than 200 new judges on the federal bench, many of whom are just obviously and avowedly right-wing. Judge Kaczmarek is no exception. At 45 years old, Kaczmarek already has a long history of right-wing conservative and anti-abortion beliefs. He led the college Republicans, the very conservative Abilene Christian University, where he wrote in the school newspaper, "The Democratic Party's ability to condone the federally sanctioned eradication of innocent human life is indicative of the moral ambivalence undergirding this party." That's the guy that heard the arguments today. During law school, University of Texas, Kaczmarek focused his attention on the legal foundations for abortion rights and attended meetings of the Conservative Federalist Society. In 2014, he went to work for a conservative legal group called the First Liberty Institute, defending clients like the Christian owners of a bakery who refused to bake a wedding cake for a same-sex couple. The following year, he became a trustee on the board of an anti-abortion organization that offers housing and adoption services to women facing unexpected pregnancies. Judge Kaczmarek's sister told the Washington Post his beliefs are strongly held, and there's no reason to doubt that. Quote, "He's very passionate about the fact that you can't preach pro-life and do nothing." Again, that's his sister who shares his views. Then President Donald Trump first nominated Kaczmarek to the federal bench in September of 2017. Democrats, understandably, staunchly opposed his confirmation and managed to hold it off for nearly 2 years. They argued that he was unfit for the role based on his anti-LGBTQ and anti-abortion beliefs.
Not only are his views on non-discrimination based on sexual orientation and gender identity concerning, I am also very alarmed by his record as a fervent crusader against women's reproductive rights and for the far-right position that someone else's ideology is more important than a woman's ability to make her own personal medical decisions. If his arguments had won the day in court, a woman trying to get contraceptive care could face barriers thrown up at her by her employer or even by her pharmacy, all because someone else thinks that their beliefs matter more than a woman's own personal decisions about her own health care.
Senator Patty Murray, who you saw there, and other opponents of Kaczmarek's nomination also pointed to his writings in which he has described being transgender as a, quote, mental disorder, called homosexuality, quote, disordered, and said that sexual revolutionaries had made the unborn child and marriage secondary to erotic desires of liberated adults. So just take a second. There's no, pretending here, right? We're well past umpire balls and strikes. We know exactly who this guy is and what he believes. Everyone does. Across both sides, right? That's why they pushed to get him on the bench. And Donald Trump persisted. He renominated Kaczmarek 2 more times. And Senate Republicans, again, led by Mitch McConnell, the whole Republican Party, this is not a MAGA thing, finally succeeded in confirming him in June of 2019. Okay. So he's a federal district judge, and he takes up his lifetime post in Amarillo. It's up in the Texas Panhandle. And there's hundreds of federal district judges. So, in the grand scheme of things, doesn't seem like the biggest deal in the world, except. That northern district, he is the only federal district judge there in Amarillo. Okay? And that brings us to why this case today is in Amarillo at all. It turns out that if you are a party in a lawsuit who wants a hard right-wing outcome, particularly on these kinds of issues, All you got to do is find some plausible reason to bring it to Judge Kaczmarek in the Northern District of Texas. Find some way to file it in Amarillo. In fact, the Republican Attorney General of Texas, Ken Paxton, has done this several times. Ken Paxton's office is right there. It's in downtown Austin, so close to the Austin federal courthouse that he could stroll over there in less than 20 minutes to file motions. But when Ken Paxton really needs the right outcome, he doesn't go there. Instead, he goes all the way up to Amarillo, a nearly 8-hour drive northwest of Austin, to file his suit specifically in Judge Kaczmarek's district, where he knows Judge Kaczmarek will hear it. It's essentially a legal loophole. Conservatives have basically hacked the judicial system to create this tiny MAGA jurisdiction with a judge who they know will rule on what they file and will favorably be relied upon to do what they want. And so far, this loophole is working out quite well for them. According to the Washington Post, Judge Kaczmarek has delivered several wins for the right, including one that struck down new Biden administration protections for transgender people, another that forced thousands of asylum seekers to return to Mexico while they awaited processing. That one was particularly rich. I mean, that was him declaring from Amarillo, Texas, federal immigration policy for the whole nation, the whole border. That asylum ruling, by the way, was overturned by the Supreme Court eventually. Late last year, Judge Kaczmarek also sided with a Christian father who did not want his daughters to access birth control without his permission, challenging a federal program that provides low-cost or free contraception, including to teens without parental consent. That's the guy who's ruling on this today. That's the guy in whose hands the fate of medication abortion in this country currently rests. So I think there's a few lessons here. One is that there's still a lot of work to be done to undo all the damage that Donald Trump, Mitch McConnell, and the entire Republican Party pulled off over the course of 4 years. It's also clear criminalizing all abortion, going after contraception everywhere for every woman and every pregnant person is going to remain a major priority for the conservative movement and the Republican Party. And the thing this situation shows us is how they must be held accountable politically, because Judge Kaczmarek holds his seat for life. He doesn't have to care about politics. That's the whole point of getting him in there. That's why McConnell and Trump expended the political capital to put him there. Republican politicians, however, should have to own every single decision that comes from him. I can guarantee you Donald Trump has enough political savvy and instincts to want nothing to do with this case. But the outcome, like the reversal of Roe itself and the sustained assault on reproductive freedoms nationwide, is on him, Trump, and the Republican Party all the way, no question.
Good. So the reason I was showing you that longer clip there from Chris Hayes, again, remember I showed you some Fox stuff, so now I'm showing you some MSNBC stuff. So, you know, you've got one side and another there. Is that kind of the forum shopping that we see, you know, maybe we shouldn't have in the federal court system, but you know, if you have over 600 judges and you can find one judge that maybe you can get to grant a nationwide injunction against something. I think that means that Congress maybe should start looking and saying, maybe should we allow just one individual federal court judge to have a nationwide injunction? So I think that given that the forum shopping that you could have on both sides, that maybe that's something. So other federal courts, so U.S. Federal Circuit Court is a nationwide jurisdiction merger of the Customs and Patents Court. Article I Court, sometimes known as legislative courts, created by Congress under Article I, judges have fixed terms rather than lifetime appointments. So that's one of the things that I was emphasizing earlier in the lecture when we talk about Article III courts versus other courts, not lifetime tenure. So these judges, immigration courts hear a lot of cases and have their own appeals court, and then you can eventually get into the federal courts. So bankruptcy courts, one of the things is that there are no state bankruptcy courts. Article 1, Section 10 of the Constitution prohibits state courts from granting bankruptcy relief. This was one of the things that the Federalists really wanted to stop from state courts from discharging debt. So they serve 14-year renewable terms as far as the bankruptcy courts. So other ones, the Court of Claims, the U.S. Court of Appeals for Veterans Courts, the U.S. Tax Courts, Court of Appeal for the Armed Forces. They review cases of lower-level military courts, the court martials. So you can see a map here of immigration courts. One of the things is that I think that we realize is that our immigration system is not functioning that well. At some point, I'm teaching a class here on immigration law, and we'll see whenever it happens. But our immigration system just is like piecemeal put together is one of the problems, and we don't have enough immigration court judges. Where do we have immigration courts? You can see we have some in Buffalo, and we have a lot near the border. So other federal courts here, we have specialized courts, the Board of Immigration Appeals, kind of the BIA, which can eventually go into the federal system. The FISA court, appointed by the Chief Justice, mostly activities in secret. Those are some things you might want to look into on your own. So Article 2 courts set up by the executive branch, laws of war, enemy combatants, Guantanamo Bay. There was the question that later we had as far as could Gitmo detainees have habeas corpus. Congress was actually trying to remove appellate jurisdiction on it. So we never really quite got to that. So an interesting thing is that I kind of alluded to earlier, COVID-19 and federal court administration. So with social distancing, so, now we're pretty much back to normal. Courts ceased having in-person proceedings. And this was big at the state level, too. We'll talk about that in our next lecture. So the Supreme Court at the end of the 2019 October term, so basically from March, whenever the COVID started, they canceled their oral arguments in March and April, had like half of them in May, and basically for that part of the term, and then the next entire year, did their oral arguments by telephone. One of the things that did happen was that somebody flushed their toilet during the oral arguments. Probably either Alito or Breyer. Alito probably because he doesn't care, Breyer because he was having some technology problems. So the justices came back in person, but there wasn't an audience for a while. And in fact, one of the things is until basically the last term, so the term that started in October of 22, they didn't actually announce their opinions in person. They announced them online in 10-minute intervals. So we have no audio of Justice Alito reading the Dobbs opinion. And we just got basically the opinion released online at 10:10 a.m. There you go. So for other federal courts, it was challenging, especially at the district court level. They saw their caseloads back up. So, if you think about a bankruptcy court case, they're hearing lots and lots of cases. They're just boom, 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 boom. Now you have to do some stuff online. What about jury trials? So they tried to space them out a little bit to keep jurors further away. But then you also have to think, well, what about if you're closing down federal courts? There's the First Amendment says you have a right to a public trial. Who knows? So administrative staff, most work for an individual judge, some work for an entire court. One of the big things that we have as far as a lot of the workload are magistrate judges. I work for all the judges in a court are appointed by them for 8 years, removed only for cause. They tend to hear less important cases, especially misdemeanors, but it varies by court and judge. So law clerks, that is something that I left kind of open here. All levels of the judiciary, they're very important for Supreme Court judges. In fact, the majority of the current Supreme Court served as law clerks for Supreme Court justices. Review cases, draft orders, a lot of their main duties. Recent law school graduates, the higher the court, the more prestigious the job, such as Supreme Court clerks. So we'll talk about the cert pool later for the Supreme Court. So we have the administrative officer, Federal Judicial Center. So some things about the federal court workload. You can see district courts, several 100,000 cases per year. Court of Appeals, several tens of thousands of cases. Supreme Court, 8 to 10,000 cert cases, 60 to 90 opinions on average, though it's kind of going down. The current backlog is biggest with immigration court judges, especially in the border states, as you're probably seeing. So next time, the next couple lectures, what we're going to look at the state judicial system and then judicial jurisdiction and policymaking boundaries. So this one ran, the last one was about 5 minutes shorter than 90 minutes. This one's about 5 minutes longer. So like I said, on average, probably about an hour and a half. So I will see you all later in this virtual space. Talk to you all later.